Property rights, water use rights, environmental regulations, and eminent domain, they may all get greater scrutiny following a U.S. Supreme Court ruling. This is the American Farmland Owner Podcast. I'm Dave Price. This week's guest is Jeffrey McCoy, although he let us call him Jeff. Now, Jeff's career is largely focused on complex cases involving landowners versus government agencies. So now let's get on the case with this attorney from Littleton, Colorado. Hey, let's first talk about your background a little bit about how'd you get here? What have you been doing?
Yeah, well, I'm a senior attorney at Pacific Legal Foundation. I've been with the organization for 7.5 years. Before that, I worked for a similar organization, Mountain States Legal Foundation. Mainly, I've been representing individuals, small business owners against government overreach, challenging regulations that affect people's property rights and their ability to make an honest living.
There are so many aspects of the legal world. Why focus on this? There's got to be something in here that you personally connect with. What is it?
Yeah, well, it's really the people and my clients. And I'm not a hands-on person very much, but my clients are. And if I can help them achieve their goals, I feel like I have some role in that. But obviously, they're contributing to society. I represent a lot of farmers, and that's, as your listeners know, hugely important. And if I can do something to help them, that makes me feel good, and also helps society as a whole if we can challenge unconstitutional regulations, make it a bit easier for people to provide their food and services for others.
What's the Pacific Legal Foundation all about? What drives you all?
We are here to represent people against government overreach. We provide legal advice and legal services free of charge. And I think that's really the big thing, because the government is so large. Has so many resources that sometimes it will just beat you down by the process. And if it's expensive, I mean, our clients are fantastic, and they go years on their cases, which is hard enough. But if you added on tens or hundreds of thousands of legal bills on that, you can see why people just capitulate and try and get out of it as soon as possible. But that our clients know, they stick with it so that everybody can benefit when we set precedents for taking down unconstitutional regulations.
Okay, so I reached out to you all after the U.S. Supreme Court weighed in on what's kind of called the Chevron case. What did the findings mean to you?
Yeah, well, Chevron, in case your listeners don't know, it was a case back in the 1980s, and essentially it said that if a statute is ambiguous, courts should defer to the agency in charge of enforcing that statute. The issue is that a lot of times the courts and judges wouldn't do the hard work of interpreting a statute. This is what we do at PLF all the time. We say this regulation, this statute, this constitutional provision means something, and courts usually have to figure that out. They have to look at various resources of what do these words mean, maybe what Congress intended with it. But under Chevron, a lot of the times, courts would just say whatever the agency says goes. And even if it went against what the statute said, and there was another case, Brand X, that came after Chevron, that even said that if one presidential administration said the statute means one thing, and then the next presidential administration says that the statute means the exact opposite thing, the statute says both, which to me is not what the law is about. The law is one thing. Congress can change it, but it can't change at the whim of the people enforcing it. Congress passed laws. It meant something, and courts should interpret it that way and not just defer to, a lot of times these are unelected officials deciding this.
On a kind of a generic level here, we see over the years where you're talking about state legislators, members of Congress, what have you. Sometimes they pass laws and either intentionally or unintentionally leave some ambiguity in there. And so how what is the best way for that ambiguity to get figured out when it's there?
Yeah. Well, I think most of the time you just have to give it a best reading, because you can look at other statutes that Congress has passed and give a good idea of what Congress meant or what these words mean. And maybe courts will sometimes get it wrong, but then Congress will go back and amend it and say, no, court, you got it wrong. But you really touched on something I think that's a big problem, is that you talked about the intentionally leaving things ambiguous. And legislators, Congress, I do think sometimes they do that intentionally, because then if something bad happens, they can blame the agency. They don't have to take blame for it. They say, oh, well, we didn't decide that. The agency did. And that is fine for their jobs. But in a democracy, you want to be able to know who to hold accountable if there is a bad regulation, a bad statute. And like I said, with Chevron and other parts of administrative deference, it pushes it on to these people who are not elected. And oftentimes, you may not even know who these people are or how to get in contact with them. You can get in contact with your congressman or your local legislator, but these people who are writing these regulations that really affect you, you may not even know who to call, more or less even be able to get in contact with them.
Okay, I may be trying to overgeneralize here, so you'll forgive me for this, but would you, and I appreciate what you do for a living here. Would the best solution to this be, if there's ambiguity, it's got to go back to Congress? Like, what is the right, and I'm not trying to eliminate your job, but when, whether it's times change, so sometimes the law or policy has to change with it, or as we've mentioned, sometimes it's just ambiguous. Either they didn't think of something or they intentionally didn't figure something out. So that there's not this overreach, there's not this misunderstanding or what have you, is it better to just knock it back to Congress or the president, or what? Like, how should we look at this?
Yeah, I think in general, it would be best to get Congress to be very specific. But there are some instances, and in this recent case, this recent Supreme Court case about Chevron deference, the court, in its opinion, did recognize that there's some times where Congress acts intentionally and for good reason, leave something ambiguous, where they say like if you're setting rates for an industry, set reasonable rates. That is a proper delegation of authority from Congress, saying, okay, we want you to decide these. The problem is that there are often times where things are not ambiguous, but courts still go, where there is a best reading. And you can be pretty certain that that's what Congress meant. But because you can't be 100% certain, courts just deferred, even though all of the best evidence, all the best arguments favor one interpretation. Under Chevron, courts just went with not the best reading. And so ultimately, to answer your question, yes, ideally, Congress should be very clear about when they are being intentionally ambiguous. Really, it's more intentionally delegating some issue, and when they're being clear. And if there is some things that are ambiguous, and it's not clear that Congress has delegated that authority, then yes, it's best to just try and get you your best answer and have Congress pass a new statute if they disagree.
So in light of that ruling, how do you look at, we have, it seems like quite a bit of cases across our country dealing with land rights, property rights, water uses, designating some area of federal land, what can be done on that land, what have you. And so some of this is at the priority of whatever party and whatever president is in power, which of course then means you may not have any kind of consistency, we go from the Trump administration to the Biden administration. We'll see what's next here. And, clearly Democrats and Republicans have different ideas about some big things. So what do you see that might be impact now in light of the Chevron decision?
I think you really focus on the main thing. There's going to be more consistency and I know that you have a lot of listeners in the ag community, and they, I'm sure, know even better than me that depending on who the president is, sometimes depending on who's in your local office, what the regulation means, what you're required to do can change from week to week, month to month, administration to administration. And now we're going to get some more certainty because courts are going to interpret these and they're going to say the statute says this. There's obviously different levels of courts, but it will eventually, there'll be one interpretation, and that's what the interpretation will be unless Congress changes it. It's not going to be changing based on the whims of executive agencies and who the president is, or like I said, even who's in your local USDA office. It's going to be consistent, and that I think is a big win because regulations take up a lot of time, and obviously there's some need for some regulations, but when you have to do all of your work trying to figure out what the regulation is, that takes away from actually doing what you're supposed to be doing your job, making food or working the land. And this will lead to, I think it will lead to more consistency across the board with what the regulations mean.
What's the most interesting case, argument, whatever that's out there right now for you? What piques your interest?
I have a couple cases. One case that we represent a farmer, Arlen Foster, his generational farmer in South Dakota, and he has a very small mud puddle that sometimes appears.
Yeah, his is about water, right?
Yeah, after heavy winter, and the NRCS, they said under Swamp Buster, which most of your listeners or some of your listeners may know, but Swamp Buster basically says if you have a wetland on your property, you can't farm it, or else you'll lose access to USDA programs like crop insurance. And so on Arlen's farm, there's a very small pool of water that sometimes appears, and it's a result of a tree line that his grandfather put in at the insistence of the USDA. And one thing Swamp Buster says is if there's a wetland that is a result of development, it's exempt. And so he argued that, well, we built this thing at your insistence. It is the cause of this pool of water. It should be exempt. And he went about 15 years ago, made that argument. The NRCS, the USDA disagreed. An administrative law judge disagreed, and basically disagreed by saying you don't have any evidence of this. So I can't side with you. About 6 or 7 years later, Arlen went back, he got the evidence. He hired a consulting firm, an environmental consulting firm that showed that this pool of water only resulted because of this tree line that he installed. And so he went back and said, I would like you to reconsider. I have the evidence that you said I didn't have before. And the statute, the provision says that says a farmer can ask for a reconsideration at any time. But the NRCS has passed regulations that say what that means, that you can ask anytime, really means you can ask if we agree with you that there needs to be a change, or that there's been something that has changed in the environment, like an earthquake. And they said, we're not giving you a review. And he challenged this and he said, no, the statute says I have to get a review. I have to have an opportunity to present my evidence again to an administrative law judge, maybe even a trial judge, a district judge. But they refused. And so we represented Arlen in this challenge just to get him a review. We said, look, statute says you need to get a review. It says he's required to get a review. He asked. It's not ambiguous, but not surprisingly under Chevron, the court said, well, you have a very good argument. And your argument makes a lot of sense and your interpretation makes a lot of sense. But under Chevron, I just have to go with what the agency said. We eventually asked the Supreme Court to hear the case. this was after this recent Chevron case was granted, and the court held on to it until they decided this recent case. And now that they have overturned Chevron, got rid of Chevron, they have sent Arlen's case back to the lower courts so that they can decide without deferring to the agency what the statute means.
Okay, talk about this pool of water. What are you talking about? How big is this thing? And this, remind me on this, it's a temporary thing. It's not always there. Is that right?
Right. It's not always there. It's not even always there. It's not even just seasonally. It depends on how much snow they get in the winter for it. And we're talking maybe 10 feet by 10 feet, few feet deep.
So it's all snow melt?
Yeah, all snow melt.
Okay.
And it's because the snow doesn't melt as fast under these trees. In South Dakota, it's cold. So the sun plays a big role in that. And yeah, but not very. But as you can imagine, it's not just that he can't farm in this, he can't farm around it, because if he even touches it, gets close to it, then he'll have violated Swamp Buster, and he'll lose access to his crop insurance and other programs that he gets through the USDA.
And so what happens in this lower court process now?
Well, yeah, so we've been going for a
it's
few
not
years
finished
already,
yet,
and we're right now we're just asking whether he's entitled to a review. I mean, if we
Okay.
win this case, he gets to go and make his case in front of the agency. And I'm sure that they'll have thoughts about what a artificial wetland and what development means, and they may argue against his evidence, but he did do a thorough job having this evidence, and he thinks that he has a good chance if he can just get a review, and that's the first step. But this is what I was saying before. These processes are long, and it takes a long time, and a lot of times people will just give up. They'll just say, fine, I just won't farm that. But he wants to maximize what he grows. He grows corn most of the years, and he wants to maximize that. I can understand that. And he thinks that he has the right to, and he's stuck with it to his credit.
And this has been going on for 15 years or what have you here.
Yeah.
So he kind of leaves this area kind of untouched. Occasionally it's got some snow melt in there, occasionally it doesn't. And so this is a complicated process, but there's still this sort of gray area, right? And so from his standpoint, he's saying that, hey, you wanted me to plant the trees to begin with. We got the trees. It's causing the slow snow melt. We got this puddle part of the year. The puddle's causing me an issue with your interpretation. Is that fair?
Yes.
And so then this takes it totally out of the agency's hand? Like, will the court be the arbiter on this finally?
Well, the court will be the arbiter on whether he gets to go to the agency, and then the agency is going to have the first say on whether they agree with his evidence and whether they think that a pool of water that is caused by snowmelt is an artificial wetland. But there is an opportunity to take it from the agency, if the agency disagrees with him, to a court. There are still deference that's left in. One thing about fact finding, for example, courts are still going to defer to fact finding. So things like whether or not the agency agrees with Arlen's evidence, that's the court is still going to be deferential on that. But on issues of law, like what does artificial mean? What does development mean? Does a tree belt count as a development within the meaning of the statute? That is something that the court will be the final arbiter on. But again, it's going to take some time to get there.
And I would assume that once you all decide to get involved in a case like this, you've heard from others who might have similar situations. Is that true?
Yeah, and Swamp Buster, and this is just one part of it. I remember reading a case that said that Swamp Buster, the court called it a bureaucratic labyrinth. And it really is. There's lots of different aspects for it. And ultimately, a lot of the time, the USDA is holding these very important programs to cover wetlands that they would not be able to regulate directly under the Clean Water Act, where these are usually very small, non-connected waters, isolated, but they're using Swamp Buster as a way to essentially regulate these areas. And they have such a complicated process for if you do violate it, what counts as a violation, all of this, that they oftentimes, a lot of farmers don't even know what they're supposed to do. And it is a complicated statute, but like I said, hopefully through more and more of these cases, and we have people contacting us about different aspects of this, and hopefully courts will clarify some of these regulatory burdens, and so at least farmers will know what they can and cannot do, rather than just being left out and not knowing, even if when they're trying to do everything right and not knowing what to do.
Let me ask you this. Do you think that the original premise of this was well intentioned to try to stop whatever potentially harmful runoff from getting pushed from somebody into the drinking system, and it was just not specific enough, too broad?
Yeah, and I think that is the key. Is it was passed, like you said, probably because people don't want, because sometimes wetlands maybe can affect groundwater or something along those lines. But it really had some very broad definitions. And actually in the 1990s, Congress fixed some of that. And this is where this provision I was talking about with Arlen came in 1996, because what the NRCS would do is they would just come back year after year after year and say, okay, this is a wetland. No, this isn't a wetland. This is a wetland. No, this isn't a wetland. And farmers were like, okay, well, I don't know what to do season from season. And so that Congress passed it and said, okay, you define it once, and then you can't change it until a farmer asks you to review it. And they add some provisions that fix some of this ambiguity, but it still continues on. And I think a lot of the time there's mission creep. And once you, as an agency, fix the really bad problems, the problems that Congress intended for you, you start saying, well, what else should I look at? Can I do this? And you go, these agencies go further and further and further, either in an effort to keep their jobs, or they start believing that really everything under the sun needs to be covered. But you see this in agencies a lot, this mission creep, where it started out very specific problem that needed to be addressed, and then that just expands and expands and expands. And I think hopefully one of the aspects of overturning Chevron is that it's going to be very clear what their objectives are. These are within your scope, these are without, and hopefully we'll stop some of that mission creep.
All right, taking the specifics out here from this case, looking at this case more broadly, the length of time. We're both dads. We both have kids. If kids come to us at 8 o'clock and say, "Dad, you forgot to feed us tonight," we're like, "Oh crap, it's time for dinner." Like, you need an immediate solution, right? Can you help us, like, explain when you're talking to clients? So when you're talking to Arlen, he's been fighting this thing forever, regardless of what these individual cases are. The length of time that it takes to pursue certain legal cases. How do you manage that, and how do you help clients who are living it, and in Arlen's case, I'm sure being tormented by it? Like, how do you get them through this process? There's not going to be a decision tomorrow or next week or whatever. Like, how do you get through that?
Yeah, well, we are honest with them from the start that this is going to be a long process, but fortunately our clients know the bigger picture, and someone like Arlen certainly he's personally affected by it, but he knows other farmers are affected by it, and he knows that keeping with it will eventually have a good outcome that will affect a lot of people. And I think that's really what motivates nearly all of our clients, is that they're working for something more. They're not just working for themselves, and that keeps them going day after day, year after year. And they know, we tell them, and we're honest with them up front, and they say, that's okay. I know it's going to be a long process, but it's important.
Have you done eminent domain cases in your career?
I have done some eminent domain, some takings from the other side where there's regulations where the government claims it's not a taking, even though it is. Essentially, regulation says you can't do anything with your property, but we're not going to condemn it. And so I've done both on both sides, yes.
You know, our part of the country, I'm joining from Iowa here. We are in the middle of pretty deep debate about whether eminent domain should be allowed when you're talking about a carbon sequestration pipeline that would go through about 5 states or so. How do you view that issue, and what should be the factors in it? Maybe not specifically about this case, especially if you all aren't part of this, but just kind of big picture broadly. How do you look at eminent domain?
Yeah, well, the big case that got a lot of immediate attention about 15 years ago was Kelo versus the city of New London, where they condemned land and gave it to Pfizer, condemned people's homes and gave it to Pfizer. And the Supreme Court there said public use, because a condemnation needs to be for public use, but they claimed that any public purpose, and in that case, increased tax revenue, could be a public use. And there was a lot of backlash, and I think that they went too far, because usually what you think of when it's public use for eminent domain is anybody, it can be used by the public, highways, courthouses, and the like. And so something like the pipeline, I think, is in a more of a gray area. I mean, it does help a lot of people, but ultimately, if it's purely benefiting a private company, I can see the arguments that that's not for public use. And ultimately, another part of the problem is that with eminent domain, oftentimes the compensation would be lower than if you were negotiating with a private company. And sometimes private companies, like in the Kelo case, can get land for a lot cheaper than they would have had to pay. And that is not fair to property owners as well. But yes, I think pipeline, I think there's a reason why it's so controversial. It's kind of in this middle ground. I think there's a lot of people who understand just taking someone's home, giving it to a drug company, that's not public use. And then on the other side, people are like, okay, you're building a highway, that is public use. That's probably where all the controversy is, in these gray areas where like a pipeline. And I know that this has been for pipelines for oil and gas. I mean, carbon sequestration. I mean, there's lots of different things. I mean, utilities usually are, I think for the most part, people can, for like telephone lines. So yeah, that's the thing, is it's the reason why it's so controversial, I think, is because it's kind of in this gray area.
Okay, far more importantly here, when is the city of Denver going to get a quality major league team that reflects the beauty of that ballpark?
That is a great question. I hope soon, but it's been a long time, and I would hope soon, because it's a great. I mean, that's part of the problem. It's a great place to hang out, even when the team's bad. So we have the highest attendance, or near the top attendance, even when the team's terrible, because it's just a beautiful ballpark, and so there's no incentive to win, I guess.
This rebuild has taken too long for
the
Colorado Rockies. Way too long. There needs to be some progress. Hey, thank you. I know we got into some complicated things, so thank you very much for the insight. Appreciate it, Jeff.
Yes, well, thank you so much for having me.
That's Jeff McCoy, senior attorney at the Pacific Legal Foundation. To learn more about Arlen Foster's case in South Dakota or the Pacific Legal Foundation, you can head to our website, AmericanFarmlandowner.com. And while you're there, sign up for our free weekly newsletter. That's the place where landowners get their news. It's a roundup of key issues, challenges, and successes for farmland owners, operators, and investors. Once again, you can find it at AmericanFarmlandowner.com. Thanks for listening, and thanks for caring about the future of our farmland.